Welcome to the third in this series of Gresham Law lectures on death, the state and human rights. This lecture is entitled, Is There a Level Playing Field at Inquests? A fair trial is one in which the rules of evidence are honoured, the accused has competent counsel, and the judge enforces proper courtroom procedures. A trial in which every assumption can be challenged. Quote by Harry Brown. In the last lecture, we took an in-depth look at the system of coroners in England and Wales, how it works, what the problems are, and how it could be improved. In this lecture, we're going to zoom in on an issue we touched upon in the last lecture, the fairness of inquests. What makes a hearing fair or unfair? What does it mean to have a fair hearing? Should the same standards that apply to civil or criminal trials apply to inquests? Do the bereaved family really get a fair hearing at an inquest? And what could be done to make it fairer? Equality of arms. One of the central concepts we will be talking about is equality of arms. This is a lawyer's term for an intuitive concept we all understand, the basic concept of procedural fairness. In short, equality of arms means that parties to legal proceedings should start on a level playing field. They should each have adequate time and opportunity to prepare their case. Neither of them should be allowed to ambush the other at the last minute with a different case to the one that they were expecting. Each of them should have access to the evidence of the other and the opportunity to think about how they're going to challenge it. At the hearing, they should each have the opportunity to call witnesses and to ask questions of the other side's witnesses. They should each have the same opportunity to make arguments before the court and put forward their case. In short, neither of them should be at any procedural disadvantage compared to the other. There are basic and obvious principles that everyone understands, but how they should be applied in practice has been debated by lawyers for centuries. For example, does equality of arms mean that if one side is represented by lawyers, the other should also be represented by lawyers? In criminal cases nowadays, many countries guarantee the right to legal aid for people who are charged with serious crimes. But in civil cases all over the world, it is common for one side to be represented by a high-powered legal team and the other to be representing themselves. After all, we live in a capitalist world where legal services, like everything else, are bought and sold, and where some people have deeper pockets than others. Legal aid schemes, where they exist, are usually means-tested and don't usually cover every type of case. A person representing themselves, a litigant in person, as lawyers call them, may have all the same opportunities in theory as the other side, but they may not be able to take advantage of those opportunities because they don't know enough about the law, the procedure, or how to present their case effectively. A big issue for centuries has been disclosure. Does fairness mean that a party should be required to disclose evidence they hold that undermines their case or supports the other party's case? Nowadays, in England and Wales, we have complex rules on disclosure in both criminal and civil cases. In criminal cases, the prosecutor is required to disclose evidence in their possession that undermines their case or assists the accuser's case. Similarly, in civil cases, we have a process of disclosure, which used to be called discovery, as it still is in the US, where each party has to disclose evidence that undermines their case or assists their opponent's case. Disclosure is really a big issue for lawyers. You will see in the news from time to time, for instance, when a prosecutor fails to disclose in a criminal case, and this causes that case to collapse. Fairness in inquests. So let's talk about inquests. First of all, A brief recap of what we're talking about. An inquest is the legal process by which a coroner investigates sudden or unexplained deaths. An inquest is always held if the deceased dies a violent or unnatural death, or if the deceased dies in custody or state detention. An inquest may also be held if the cause of death was unknown, unless the post-mortem investigation has established the cause of death. Superficially, an inquest looks a lot like a trial. It takes place in a court, witnesses are called, submissions are made, there's a coroner, who's the judicial figure, and sometimes the coroner sits with a jury. But an inquest is quite different from a trial. In a civil or criminal trial, you have parties: prosecutor, the defendant in a criminal case, the claimant or defendant in a civil case. The trial is a dispute between those parties. The parties decide what evidence or arguments will be put forward. The court hears both parties' evidence and arguments and decides the issues, and one party wins and the other party loses. This is what we call an adversarial process. An inquest, in theory, is not an adversarial process. It's an inquisitorial process. It is the coroner who decides what witnesses to call, what questions should be asked, and there are no parties as such. There are a number of interested persons who are involved in an inquest, such as the family of the deceased and any individual or institution who were involved in the deceased's death, but strictly speaking, they are not parties. Nor does an inquest have winners or losers. A coroner doesn't find anybody guilty or not guilty. A coroner doesn't find anyone civilly liable to anyone else. The coroner simply returns a verdict or conclusion as to how the deceased came by their death, and that conclusion may please some of the interested persons and displease others, but formally speaking, nobody wins or loses an inquest. So, some might say, does an inquest really need to be of the same standards of fairness as a criminal or civil trial? After all, it's the coroner who's responsible for conducting the investigation. The interested persons merely participate, but they aren't parties. They don't win, they don't lose. So how can we judge an inquest as if it were a trial? That argument might make sense in theory, but it falls apart when it collides with reality. When a person dies, and a powerful institution may be at fault, whether that be a police force, hospital, prison, private company, or anything else, that institution is normally concerned to protect itself from reputational damage and civil liability. So in virtually every case, the institution implicated in the death will be represented at the inquest by a high-powered legal team. In a big case, their team is likely to be led by Queen's Counsel, senior counsel. Their team will fight tooth and nail to protect the institution from criticism. They know that if the inquest criticises them, it will be all over the media, and they will face civil litigation, and perhaps even a criminal prosecution. Similarly, individuals who may be criticised and who may face criminal or civil liability as a result of the death are also going to do everything they can to protect themselves. They are unlikely to have deep pockets as deep as institutions they work for, but they can often rustle up some form of legal representation from a body such as the Medical Defence Union, if it's dealing with doctors, or the Police Federation, if it's dealing with individual police officers. Again, therefore, they are often represented by experienced lawyers at an inquest. I should emphasise that this isn't a criticism of these people and institutions for instructing good lawyers. Far from it. Any of us would do the same if we were in the same circumstances. But that is my point. You see, the bereaved family of the deceased, the people who have suffered unimaginable pain of losing a loved one, are often not legally represented at all. they have no automatic right to legal aid, and over the years I've known many bereaved families who felt that they've been excluded from, marginalised and treated poorly by the coronial process. In short, the inquest process suffers from an inequality of arms. We're now going to go look at the history and the role of bereaved families at inquests. When I first started representing families at inquests about 30 years ago, their rights were very limited. Immediate family members of the deceased did not have the power to ask questions of witnesses at inquests under the Coroner's Rules 1984, either in person or through their lawyers. There was no legal aid in those days for representation at inquests, nor were there any clear rules about disclosure. Coroners decided what to disclose to families. I remember attending inquests where the lawyers representing, say, the police force or prison service would turn up with large files of papers, none of which had been disclosed to me. And what was particularly problematic was that the family had no right to see witness statements in advance. So when a witness started giving evidence, the coroner, the police, had seen the witness statements, whereas the family had not. Lack of legal aid and the Marchioness Action Group. In the early hours of the 20th of August 1989, there was a collision between two vessels on the River Thames in London. The pleasure steamer the Marchioness sank after being hit twice by the dredger Bobel at about 1:46 a.m. This tragedy became known as the Marchioness disaster. 51 people died, including a very close colleague of mine from my chambers at the time. The inquest into the death of these 51 people on the River Thames lasted about a month, between March and April 1995 at Hammersmith Town Hall. At the time, there was no legal aid for inquests. Indeed, it would be many years before a formal system of legal aid would be introduced for bereaved families. Now, the Marchioness Action Group, representing both the bereaved and the survivors, sought a meeting with the then Lord Chancellor before the inquest commenced. At that hearing, they told him that if he did not fund legal representation for the bereaved families, each of the 51 families would participate in person at the inquest and ask questions of each witness, as was their right. This would mean that the inquest would be likely to last for about a year or more and cost far more public money than if joint representation was funded by the government. The submission was entirely the idea of the action group, and it worked. The government blinked. Only one working day before the inquest was due to start, the Lord Chancellor announced a one-off lump sum would be granted to the lawyers representing the bereaved families. There was no requirement for timekeeping, and division of the lump sum was left up to the lawyers. This was a rare occasion where funding was granted, and as I say, it was very much a rare exception. Later, when an exceptional funding scheme was introduced for inquest, the Lord Chancellor's guidance on the scheme specifically referred to the grant made for the Marchioness disaster inquest, and this I shall return to later. The story of Anne Power. Anne Power is one of the bravest women I know. She's dogged, determined, she does not quit. Anne's husband and father of their 3 children, 51-year-old Onese Power, died during a dangerous high-speed Metropolitan Police pursuit in Kentish Town on the 17th of August 1997. Onese had been disqualified from driving, but he loved his motorbike, and on that Sunday morning he was spotted travelling at quite a crack along Camden Road, NW1, on his distinctive Ninja Kawasaki. It was a powerful motorcycle with a high volume rev and noise, and hearing the growl of the engine, and surmising that Mr. Power was driving over the 30-mile-per-hour speed limit, two officers in a Vauxhall Cavalier decided to pursue Mr. Power. A high-speed pursuit then ensued through the busy streets of Camden and Holloway Road, with at least 4 other police vehicles joining in on the chase, which ended in a narrow side street where, with the convoy of police vehicles hot on his wheels, at a left-hand bend where the Royal College Street meets with St Pancras Way, Mr. Power hit some bollards coming off his bike and died instantly at the scene from fatal injuries resulting from the collision. In 1998, the inquest took place at St Pancras Coroner's Court. Mrs. Power didn't have the right to legal aid. There was no legal aid for inquests, and she was unrepresented at the hearing. Everyone else in court was armed with a great wad of witness statements and other documents, but Anne Power was empty-handed. Despite requests from her, she did not receive disclosure of witness statements before the inquest. One of the key issues at the inquest, which I had to investigate, was whether the police vehicle, that was November 1, had made contact with Mr. Power's motorbike in the closing seconds of the pursuit. Several eyewitnesses had come forward to express concerns about the safety of the police operation and the decision to continue the pursuit of Mr. Power at dangerously high speeds along extremely narrow residential streets with parked cars on either side, further limiting any passing space and potentially endangering passers-bys, not to mention Mr. Power himself. One eyewitness, who was walking home along St Pancras Way, stated that she saw a police car come towards her, followed by 4 other police cars, all with flashing lights and sirens. She made 2 statements in which she alleged that the leading police vehicle in the chase, driven by the police, had closed in on Mr. Power and, perhaps attempting to cut him off on the approach to the bend, had made contact with the handlebar of the Kawasaki. Quote, "Shortly after they passed me, I heard the sound of squealing brakes and the dull thud of a fast-moving vehicle hitting a body. I looked back to see what had happened. The first police car had stopped and I saw a police officer get out and lift the man from the road. The other police vehicles were having to brake very sharply to avoid hitting the first police car. I thought they were all going so quickly that there was going to be a multiple accident." End of quote. However, this key witness was unable to attend the inquest due to ill health, and her statement was afforded little weight during the hearing. And since Mrs. Power had not seen this statement as part of the disclosure, she was not able to request an adjournment. This was unfortunate, to say the least. Indeed, black rubber marks had been found on the police vehicle, which were possibly consistent with such contact, but Anne argued that the police inquiry into the fatal incident was patently insufficient. There were failures to test the police vehicle at the speed and the speed at which it was travelling at the time of the death in order to replicate the tyre marks found at the scene and to forensically examine the damage to the police vehicle, which could have been caused with contact with the motorcycle driven by Mr. Power. Indeed, a road traffic accident investigator assigned to the case had ruled out such a finding because he said he'd been able to remove the marks on the side of the police car with a bottle of household Jif, a detergent cleaner. The irregularities in the inquest did not end there. Without the benefit of disclosure of relevant police and witness statements before the hearing, neither Mrs. Power nor the jury could have known at the time of the inquest that both the driver of November 1, the lead-in police vehicle, and his passenger had made virtually identical statements, identical save for a few words which made no contextual difference to the substance. Furthermore, rather than writing up their accounts on the day of the incident, or as soon as was reasonably practicable to do so, the officers most closely implicated in the accident made their identical statements a full 5 days after Mr. Power's death. Anne had to cross-examine these officers blind, without sight of their accounts, and therefore neither officer was interrogated about the disquieting similarities in their statements. Now clearly the coroner had seen, and hopefully read, closely both officers' statements, and would have picked up on, and should have asked, how it was that the police officers' statements were so similar, how they had been compiled, and as they were written 5 days after the incident, and whether there was any degree of after the event reconstruction. All of this was relevant not only to the issue of the fatal accident, but also to the question of whether the police pursuit of the deceased motorcycle was dangerous. But rather than painstakingly examining these anomalies in police procedure, it seems that the coroner was inclined to accept the police's account without too much close scrutiny. Critically, therefore, the jury were not made aware of the issue of credibility and potential impropriety which could flow from such irregularities, and I have no doubt that this would have been the first thing picked up upon by any skilled advocate. Meanwhile, the police officers were represented and thus shielded by senior counsel, and had a number of traffic investigators given evidence to back up their version of events. Nevertheless, Mrs. Power did her best to question the police officers involved about their speed, the speed of the police vehicle, stopping speeds and distances. Remember, this is a woman who's lost her husband. She's not an expert on motor vehicle car chases and stopping speeds, nor did she have any legal training or the benefit of having seen the witness statements, the incident report books, but she did her best. It was like having an arm tied behind her, being blindfolded, and asked to take on a world champion boxer in a boxing match. Despite all of this, the jury returned an open verdict. A year later, after the conclusion, in 1999, Mrs. Power came to me because she wanted to pursue an action against the police but was unable to secure funding. Her case stopped there. I thought this was the end of the road for Mrs. Power, but Mrs. Power had other ideas. She did not give up. Nearly 20 years later, Mrs. Power contacted me again. "Do you remember me?" she asked. Of course I did. I told her so. Anne said she'd found some new evidence. A report had come to light dated the 21st of April 1999 by an expert in road traffic analysis, which disagreed with the opinion of the traffic investigator of the time that the marks on the police vehicle did not represent contact with Mr. Power's motorcycle. His conclusions as to the accident were that Mr. Power, quote, positioned himself near to the crown of the road with a view to smoothing out the bend. It would appear that the driver of the police vehicle has attempted to overtake on the near side. Because of the presence of a parked Audi car, That overtake necessitated that the driver going extremely close to the motorcycle. Because the police car right alongside, Mr. Power was unable to lean his motorcycle in order to take the bend. When he attempted to lean his motorcycle, a contact occurred between the handlebar and the door of the police car. Unable to lean over and negotiate the bend, Mr. Power applied heavy braking to mitigate what was now an inevitable spill. However, he ran wide, mounted the curb, and struck the bollard. End of quote. A subsequent CPS review, that's Crown Prosecution Service, of the case read, "I am uneasy about the whole incident. We can all appreciate how easy it would have been for November 1, the police vehicle, to have nudged the motorcycle on the approach to the bend. I am not surprised the family of the deceased feel unhappy with some aspects of the investigation." End of quote. My goodness. In 20 years, I hadn't seen or heard from Anne, but she had continued steadfastly to work all alone on her case, trying to get hold of police records, trying to get disclosure of contemporaneous notes of the incident and specialist forensic road traffic accident reports. And it turned out there was a ton of documentation which she never had access to during the original inquest. We met, and I agreed to help her take an appeal to the High Court. We issued proceedings according to Section 13 of the Coroner's Act 1988, seeking an order that the original inquest be quashed and a fresh inquest be held. We were successful in our appeal before the Divisional Court, and the judges were full of praise of Mrs. Power and for her tenacity and strength in those long 20 years she had spent fighting for justice. In the judgment, the Honourable Mrs. Justice Nicholas Smith said, quote, "The claimant did not have the benefit of legal representation at the inquest into the death of her husband. Her request for disclosure of statements in advance of the inquest had been refused. It was clear from her questioning of the police officer that the case put forward on behalf of the deceased was that he was entering the left bend from College Road, but was unable to lean into the bend to safely navigate it because of the presence of the police vehicle on his near side. At some point, there was contact between the two vehicles. The two police officers denied this version of events. The evidence of the driver of the vehicle and his passenger was critical. The fact that the two officers had made, in effect, identical statements was a matter upon which each could and should have been questioned so as to test the credibility and veracity of each account, in particular as to speed, distance, and sequencing. One independent witness provided two witness statements, which on the face could be taken as supporting the assertion of the speed and contact between the two vehicles. Her statements were read. No opportunity was afforded to the unrepresented claimant to adjourn the proceedings for this witness to attend. End of quote. The justices found there were irregularities in the inquest proceedings, insufficiency of inquiry, and that this, along with the relevant new evidence, meant that it was in the interest of justice for a fresh inquest to be ordered, adding, quote, "It would be open to a new jury to return a narrative verdict which it is hoped will bring a measure of closure for the claimant who for 20 years has fought tenaciously on behalf of her husband." End of quote. Death on the Rock. One of the biggest drivers of change in the last 30 years has been the case law of the European Court of Human Rights. In 1995, the court decided in a case called McCann against the United Kingdom. This was a dramatic case also known as the Death on the Rock, about the shooting of 3 suspected provisional IRA men by SAS soldiers in Gibraltar. It's a judgment that's well worth reading, but for our purposes today, we are particularly interested in what the court said about investigations. In McCann, the court crystallised the idea that Article 2 of the European Convention on Human Rights, the right to life, isn't just about whether the state kills you, it's also about what it does after you've been killed. It said that Article 2 requires that there should be some form of effective official investigation when individuals have been killed as a result of the use of force by, inter alia, agents of the state. In McCann itself, it found that the obligation had not been breached and that the inquest that had taken place was sufficient. Jordan. The court in McCann didn't go into much detail about what the investigation required, but in a 2001 case called Jordan against the United Kingdom, involving a police shooting in Northern Ireland, it set out the requirements of an effective investigation in much more detail. One of the things it said is that the next of kin of the victim must be involved in the procedure to the extent necessary to safeguard their legitimate interests. In Jordan, the court was very critical of the inquest process. It said about the non-disclosure of witness statements, quote, "The previous inability of the applicant to have access to the witness statements before the appearance of the witness must also be regarded as having placed him at a disadvantage in terms of preparation and the ability to participate in questioning. This contrasts strikingly with the position of the Royal Ulster Constabulary, who had the resources to provide for legal representation and full access to the relevant documents. The court considers that the right of the family of the deceased, whose death is under investigation, to participate in the proceedings requires that the procedures adopted ensure that the requisite protection of their interests, which may be in direct conflict with those of the police or security services implicated in the events. Prior to the recent development in disclosure of documents, the court is not persuaded that the applicant's interests as next of kin were fairly or adequately protected in this respect." End of quote. This was a massive step forward as recognition that families were at a major disadvantage in the traditional inquest process was being recognised for the first time. As Labour politician, the Right Honourable Emily Thornberry MP stated, quote, "The Human Rights Act is not a terrorist charter. It enables ordinary citizens to seek redress when the government breaches fundamental freedoms enshrined in the European Convention on Human Rights, such as the right to a fair trial, the right to life, and freedom of expression." End of quote. The court in Jordan also considered the lack of legal aid for the bereaved applicant, and this formed part of the background to their finding that there had been unreasonable delay in the investigation of the death. However, given that the bereaved applicant had been represented, they did not directly confront the question of whether there would be a duty under Article 2 to fund legal aid for the bereaved family. Meanwhile, from 2001, the Legal Services Commission did have power by virtue of a direction made by the Lord Chancellor under the Access to Justice Act 1999 to fund legal representation at inquests. As stated above, when these provisions were introduced, reference was made to the one-off grant that had been made to the Marchioness Inquest. This would be only done where there was significant wider public interest, or where funded representation of the family of the deceased was required to carry out an effective investigation into the death as required by Article 2. There was, however, a further significant limitation. There was no power to waive the means test, so that families who were earning slightly too much to get legal aid but not enough to afford representation themselves, had no prospect of obtaining representation. Khan. The next big case was a judgment in the Court of Appeal in the 2003 case of Khan. This was a very sad case where the claimant's 3-year-old daughter, Najish, had died in hospital. The claimant and his wife had been so devastated by her death that they suffered a breakdown and felt unable to deal with people. There was no legal aid for them to be represented at the inquest into her death because they had slightly too much money to pass the means test. The Court of Appeal held, exceptionally, that the lack of legal aid had breached the state's obligation under Article 2. It said, quote, "The inquest will not be effective unless Najish's family can play an effective part in it. The evidence shows that they are in no fit state to play that part themselves. Although the function of an inquest is inquisitorial, and in the overwhelming majority of cases the coroner can conduct an effective judicial investigation himself without there being any need for the family of the deceased to be represented, every rule has exceptions, and this, in our judgment, is an exceptional case." End of quote. So, from the 1st of December 2003, the new Regulation 5C of the Community Legal Service Financial Regulations 2000 gave the Lord Chancellor power to waive the means test. So, from then on, families could, exceptionally, get legal representation at an Article 2 inquest, but it remained exceptional, and the family still had to undergo intrusive means testing even if the means test was ultimately waived. There has been a lot of criticism of this, particularly in cases where a person has died in prison or detention. The charity Inquest has produced a useful timeline of legal aid cases, which shows that over the years many reviews and reports have called for wider availability of legal aid for bereaved families. That include the Corsten Report on women in prison, the Harris Review on the deaths of 18 to 24-year-olds in custody, and the Angelina Review of deaths and serious incidents in custody. I've put some of these examples up on the slide, and you will find a full timeline on the Inquest website. The next phase of change was the Coroner and Justice Act 2009, which we looked at in some detail in the last lecture. Section 51 of the 2009 Act would have brought representation at inquests into the ordinary scope of legal aid, whether the deceased had died in prison or detention, or had been a member of the armed forces or active service. However, Section 51 was never brought into force and was ultimately repealed by the coalition government, which came into power in 2010. And even if it had been brought into force, it would not have automatically waived the means test. LASPO. Famously, the coalition government then brought forward the Legal Aid Sentencing and Punishment of Offenders Act 2012, known to lawyers as LASPO. This legislation is infamous, and rightly so, for making drastic cutbacks in the scope of legal aid across a range of areas. It has fundamentally undermined access to justice in many ways that are outside the scope of this lecture. As regards inquests, LASPO confirmed that representation at inquests, as opposed to advice, was outside the normal scope of legal aid. It remained possible for exceptional case funding to be granted for representation at an inquest, where representation is needed to meet the procedural obligations under Article 2, or where there is a wider public interest. Meanwhile, when it comes to disclosure, I have to acknowledge that the inquest process has improved a lot since I first started working in this area as a result of the 2009 Act and the rules made under it. Nowadays, Rule 13 of the Coroner's Inquest Rules 2013 requires that the coroner disclose certain documents to interested person, and that disclosure is to be expected. There's a presumption of it. This has been a big step forward in terms of procedural fairness for the bereaved families. But what the state gives with one hand, it takes away with the other. The 2009 Acts produced some improvements to the coronial system, as I've acknowledged in the last lecture, but without legal aid, some bereaved families are still unable to get justice through the coronial process. So let's look at the current situation. So where are we today? Families in England and Wales have never enjoyed automatic, non-means tested right to legal representation at inquests. The situation, however, is different in public inquiries. At a public inquiry, the core participants, the equivalent of interested persons, can be funded, and there is a mechanism for determining that funding pursuant to Section 40 of the Inquiries Act 2005 and the Inquiries Rules 2006 Rule 22, which give a chairman of an inquiry the power to, where it's appropriate, to make an award for legal representation. And Rule 22 makes it clear that there are things that the chairman can take into account in determining that award, such as the nature and the scope of the work to be funded, the hourly rates to be paid, the upper limits on the sums or number of hours that will be paid, and the frequency in which the bills will be submitted to the chairman and his team. Moreover, the government has set rates for inquiries to avoid arbitrary payments. And let me say this, the rates for public inquiries seem positively generous compared to the amounts paid for inquests, and I will return to this later. You see, in this regard, inquiries steal a march on inquests. You see, legal representation at inquests remains exceptional, and it remains means tested, although there is a power to waive means. And this can mean major barriers for bereaved families. Some bereaved families lacking legal representation have to prepare the case and cross-examine the witnesses themselves. A bereaved family member quoted in Inquests, the charity February 2019 briefing on legal aid, said, quote, "We had to do everything ourselves. We had no lawyer at the inquest. Those 3 weeks were the most terrifying thing I'd ever done in my life. I had to cross-examine the witnesses and it was absolutely terrifying. And they had lawyers. There needs to be a level playing field. A family member should never be put through that." End of quote. Another family member quoted in the Inquest's September 2020 submission to the Justice Select Committee said, quote, "The lack of funding meant I had to cross-examine the pathologist myself on my dead daughter's body, something that no parent should ever have to do." End of quote. In the very same submission, a different bereaved family member recalled that in their inquest, the hospital had 7 of their legal team in attendance, as well as an external barrister. We can see that many families are still in exactly the same position that Anne Power faced back in 1998. Can you imagine you've lost a loved one, having to prepare the case, get your head round the evidence and cross-examine the witnesses who may have been to blame for your loved one's death? Nobody should have to do that. And even when legal aid is in place, the rates of pay for lawyers are often low. The same report referred to an inquest where counsel for each of the 4 police interested persons were being paid 8 times more than the legal aid rates. In saying this, I'm not seeking to garner sympathy for lawyers like me. I'm simply pointing out the massive inequality of arms, where those representing powerful institutions are better resourced than those representing families. In fact, the rates of pay have become worse as a result of LASPO and the austerity measures of the 2010s. Legal aid fees have taken a big hit in both real and nominal terms. The recent Bar Council report, running on empty, published in January 2021, pointed out that legal aid rates for inquests have been squeezed. A barrister gets £900 for the brief fee and £450 a day. Now, that might not sound too bad until you consider what will have to be done, namely numerous hours of preparation for each day in court. As one barrister said in the Bar Council report, quote, "You may often get 3 or 4 lever arch bundles of paper, and as a representative for the bereaved family, you are central to the process and you have an interest in all of the witnesses. You are challenging the witnesses rather than just being there to protect their interests, and you are doing the bulk of the work. And the representatives of the state have a lower stress job, a much easier job, and they get paid much better. If you might be preparing a 2-week inquest with 15 to 20 witnesses, including cross-examination of consultant psychiatrists and challenging witnesses to cross-examine, and have 3 or 4 lever arch files of papers and £900 to cover all of your preparation on the first day of the inquest, it is hopeless." End of quote. As another colleague said in the same report, quote, "If I'm preparing for an inquest, I spend 2 to 2.5 days, really high-stress days preparing, and often on the weekend. So if the inquest starts on a Monday, I would prepare Friday, Saturday morning, and Sunday. I finished an inquest yesterday. That is exactly what I did. I worked the last 3 weekends straight. I did the preparation by working on Saturday and all day on Sunday, and really early in the mornings and late at nights during the hearings. If you have an absolutely lovely client who's perfectly reasonable but crying all the time, who's absolutely desperate for the state authorities to realise that they have screwed up, and there are 4 barristers who are getting better paid than you are up against, and you're effectively cross-examining and getting to grips with the role of a GP, the role of the psychological therapy service, the role of the psychiatrist, the community mental health team service, the role of the police and how the police systems work, all in an adversarial environment. It is quite intense. And in the moment, I do not feel like it's too much. I get on with it. But then the day after, someone asks me, "What's it like doing inquests for £900? And I'm like, "It's not very good. It's not very good." End quote. Now, as I said, I'm not saying any of this to elicit sympathy for barristers. Ultimately, it's not about us, it's about our clients, people who've lost their loved ones, often in the most tragic circumstances. When powerful institutions are defended by much better paid and better resourced legal teams, how can it be said there is equality of arms for a grieving family? Things can get even more complicated when different members of the family have different views and can't work together, yet legal aid will only pay for one team. There's a further very serious problem faced by many families. Even if they have obtained legal aid for an inquest and have obtained a waiver of the means test, what happens if they want to challenge the decision of a coroner? For example, if the coroner makes a ruling about the scope of the inquest or about what evidence should be considered that they disagree with. In most cases, the only way to challenge these decisions is by way of a judicial review in the High Court. And although judicial review is within the scope of legal aid, it is always means tested, and there is no power to waive the means test. So, families can end up in a situation where they believe the coroner's decision to be wrong, and they have a strongly arguable case, but they are unable to challenge it because they just can't afford to pay. And even if their lawyers decide to act pro bono, they could still be liable for the other side's costs if they lose, which could be substantial costs. So where should we go from here? Let's wrap up this lecture by talking about where we go from here. First and foremost, I believe there should be automatic, non-means tested legal aid for bereaved families in all cases where Article 2 is engaged, including deaths in custody and detention. I endorsed the charity Inquest campaign for legal aid for inquests, which you can read about on their website. I've listed some of the key points on the PowerPoint slide. But I also think there's room to go further. There are some deaths where Article 2 is not engaged, but where legal aid is still needed. Even where Article 2 is not in play, it's still vital to hold institutions to account. Sometimes, for instance, the evidence in an inquest is so technical and so complex that it's virtually impossible for the family to represent themselves. I'll give an example. In 2016, I was representing a family who'd lost a child in the flooding in Surrey. They believed that the flood waters had crossed over a landfill site and noxious toxic fumes had entered their dwelling, killing their son. Now, this evidence was in dispute. Article 2 was not engaged as the coroner had ruled, and so the family were not entitled to legal aid. But yet, the evidence was very scientific, very technical, and very complex. Even the lawyers had difficulties with some of the legal and scientific concepts. This was a family who were just unable to represent themselves and needed lawyers, but had no means of legal aid. You see, the inquest is often the only chance at achieving justice for a family who have gone through the worst experience of their life in losing a loved one. Bereaved families need and deserve legal representation. So I think we should have a two-pronged approach. There should be automatic, non-means tested legal aid for every Article 2 inquest, and there should be a discretion to provide legal aid in non-Article 2 inquests, which should be non-means tested. Finally, let me say this. We need to create a route of appeal against coroner's decisions. As I said in the last lecture, coroner's decisions on issues such as scope of the inquest or what the evidence will be considered should be appealable to the chief coroner. These appeals should be considered as part of the inquest and should be funded under the same legal aid certificate as the inquest. This would mean that no one would be denied the opportunity to challenge an unjust decision because of lack of funds. Thank you.